Good morning, everyone. The 14B District Court is now in session. My name is Irene Washington, and I'm the judge that will be presiding over this session. Please make sure your devices are muted until your case is called. Once the case is called, then please unmute your device. Wait for the attorneys to place their appearances on the record once they have stated who they represent, and then you will state your name. Once your name has been stated, we will proceed with the case. Make sure your camera is on as well. The court will call the case of Nagarjuna Dukampudi, case number 25W000992.
Paul Barnett on behalf of the township.
Sean McDermott on behalf of Mr. Dukampudi. Your Honor, this is an adjourned date. We had resolved the initial civil infraction. However, there were two additional civil infractions on the ticket in my file that we were trying to determine if there were any state charges or otherwise. And I don't know if there's been any progress in that regard, or I don't have any information.
Yeah, nothing has been submitted to the township. There may be something down the line for your client, Sean, from the state, but I don't have any information as to that. So I'm willing to just forge ahead with the original agreement that we had reached, which was an amendment to impeding traffic and admission on behalf of your client, dismissal of the original count.
Very good. I do have full authority. We accept that, Judge.
Thank you. I'm writing it up.
So just so I'm clear, Mr. Barnett, even though the ticket is written under Ypsilanti Township, only the first charge is a township charge. The other two are state charges.
Well, there may be. I only have the one charge myself, but they may have submitted for misdemeanor or otherwise review by the state prosecutor. There could be an ordinance violation and then additional charges. Certainly, This is not going to be a double jeopardy situation.
Okay. So under this ticket number, you only have the one charge.
Or you guys should have talked before you got here today.
It was just a clarification, Judge. We're all set.
Okay. So in my ticket, as I said last time we were here, there is only one charge on this ticket. There's only one charge. If there are other matters, the court does not have those. Under 25W000992, there is only one charge listed, and it's failure to yield. So we are going to be dismissing that count and adding a count 2 of impeding traffic, for which you have the authority to admit responsibility for your client, correct?
Yes, Judge. Thank you.
Right. And the fine in that case, and that's for an event that happened on, maybe we're talking about different days, so let's make sure we're even talking about the same date. This is for an event that happened on June 25th, 2025 at the vicinity of South Huron Street and I-94 West. Is that correct? All right. The fine in that particular case is $180. Can your client pay it today?
We had 2 weeks, Judge. He's out of state, I believe.
Then I will give him until pay by September 8th.
Very good. Thank you, Judge. Thank you, Mr. Barnett.
Not wanting this. Thank you.
Yep. Have a good day, Judge.
You too. Well, we'll call the matter of the state of Michigan versus Aaron Teachout, case number 25-00308.
Tiffany Woods for the people.
Good morning, Your Honor. John Vincent on behalf of the defendant, Aaron Teachout. Your Honor, this is the time and date set for the first pre-trial. I believe we have come to an arrangement by which Mr. Teachout will take the plea deal that is offered. I'd like to have the prosecutor read it into the record, but my understanding is it would be a changing of the first count of DV second to a DV first, dropping the second count, and asking for no upfront jail time, plus other things like Mr. Teachout getting a alcohol assessment and other things related to that.
That is correct, Judge. He would plead to an added count of DV first offense, a sentencing agreement to no upfront jail, a referral to probation, and an alcohol assessment, and we would also agree to dismiss count 2.
And Your Honor, I've had a chance to go over this agreement multiple times with Mr. Teachout. He understands he has an absolute right to trial. He has a right to a jury trial. He has a right to have me represent him at those trials, or another attorney should he wish. I know you will explain those rights again to him, but I just want to let you know that we have talked about this plea in detail.
Thank you. All right, so you understand you have a right, well, first of all, do you understand the offer that's being made, which is for you to plead to an added count 2 of DV first degree, which is a misdemeanor carrying a maximum penalty of up to 93 days and or $500 fine. There must be an referral to probation. There's an agreement to no upfront jail. And did you say restitution?
I don't think there's any restitution in this case, Your Honor.
Okay, there was the third thing that I missed. So I got the DV first degree, the no upfront jail, a referral to probation, and something else you said, Ms. Woods.
Judge, we would like to have an alcohol assessment done because
Thank
we
you.
believe that is the underlying problem that needs to be addressed with this defendant.
Thank you. Knew it was one more, and you have to have an alcohol assessment. Do you understand the offer, sir?
Yes.
And is that what you want to do?
Yes.
All right. Please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes.
All right. I'm going to lower your hand. I'm going to go over your rights that you have that you're going to be given by entering into this plea. Please stop me if you have any questions or if you feel like you need to speak with your attorney again, okay?
Okay.
You have the right to have a trial with your jury, at which time you can call witnesses to speak for you. You can get an order signed by this court to require that those witnesses come to court. You have the right to see, hear, and question any and all witnesses that are called against you, and you have the right to be a witness for yourself, or you could choose to remain silent. If you chose to remain silent, the prosecutor could not comment on that. In addition to that, you have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. Do you understand those rights?
Yes.
Do you understand you're going to be giving up each and all, every one of those rights, and you're not going to be having a trial of any sort?
Yes.
You also understand that there's no automatic right to appeal this decision. So the decision you're making today, Mr. Teachout, in all likelihood is going to stick with you. You understand that part?
Yes.
And if you were on probation, parole, or bond when this happened on July 18th of 2025, you could be in violation of that probation, parole, or bond. Were you on any of those on that
No.
date? Okay. And if you're not a U.S. citizen, you could have immigration consequences. You understand that part?
Yes.
To the charge of domestic violence. In the first degree, how do you plead, sir?
Guilty.
Anyone promise you anything other than what we just put on the record to get you to plead guilty?
No.
Anyone threatening you in any way, shape, or form?
No.
All right. Let's turn to the date of offense itself, and I have some questions for you. So on July 18th, 2025, were you at the vicinity of 2861 International Drive, here in Ypsilanti Township?
Yes.
And you were at an apartment there, correct?
Yes.
Was there a Shyla, let me see. Was there a Shyla Wise who was present?
Yeah.
And while you, were you two in a dating relationship or something?
Yes.
Okay. Did you live with her or you just were dating or what?
We live together.
Okay. And on that date and time, did you hit or push her or something?
Yes.
All right, what did you do?
I hit her.
Okay. She didn't give you permission to do that, I take it?
No.
I find that there's a factual basis for the plea that's been willingly and knowingly made. And there is a count 2 in this case. So actually, he's pleading to an added count 3. Counts 1 and 2 will be dismissed. Sentencing will be on September 22nd. 2025 at 10 a.m.
I'm sorry, Your Honor, can you repeat the time? Was it 9 or 10?
10. Does that work with your calendar, Mr. Vincent?
It does. September 22nd, 10 a.m.
Correct. And Mr. Teachout, you need to contact the probation department to schedule a pre-sentence investigation report. I'm going to give you the phone number now, and I'm going to give the phone number to everybody on the call. So everybody, please write down the phone number. Let me know when you have a pen, Mr. Teachout, okay?
I'm ready.
734-483-7336.
What was the last two?
36. So it's 7336.
All right.
Please call them tomorrow after 9 a.m. Okay? And they'll schedule your interview for you.
All right. Thank you.
You're welcome. Well, let me, so he has some contempt hearings on October 2nd, but I think I'd like to get him sentenced on that date. I'm gonna move them all up. What? Some of them. what?
No, I'm double checking. For the Thursday, you just so that you're aware, not that that matters with the company, but October 2nd. It is open currently.
I'm moving October 2nd to September 22nd. I'm telling you what I want to do. 22nd.
All of the contents.
Mhm.
Oh, okay, that's what I was missing. It was moving those ones back to the 22nd.
Correct.
Okay.
All right, we're all set. Thank you.
So that
Thank
date
you.
for the 22nd is still good.
Yes, that date is good. I'm going to move his other cases to that particular date.
Okay. All right. Thank you, Your Honor.
I want to see him sooner. That is why, and he shouldn't have to come back twice. All right, I'll see you then on September 22nd, Mr. Teachout, okay?
All right.
Thank you. You're all set, sir.
Thank you, Your Honor. Thank you, Ms.
You're
Woods.
Ypsilanti Township versus Devon True, case number 25T00297.
Paul Barnett on behalf of the township.
Kyle Bordeaux on behalf of Davon True. Ms. True, please unmute yourself, turn on your microphone and your camera, and state your name for the record.
Davon True.
Thank
Thank you,
you.
Your Honor. Today's date and time set for pretrial. We are at this time asking that the matter be set for final settlement conference. And I know it may be a little soon, Your Honor. Is there any way we can do this month's on Friday?
No, we cannot.
Okay, I figured it was a little soon, but thank you, Judge.
Final settlement conference, October 31st, 2025 at 9:30 a.m.
Okay.
And jury selection will be on November 7th, 2025 at 8:30 a.m. The final settlement conference is going to be via Zoom, ma'am. But the jury selection will be in person.
Okay.
Right. Your bond is continued, ma'am.
Thank you, Judge.
You're welcome. See you all then.
That hearing had a little bit of everything. Judge Irene Washington presided over a morning where cases ranged from a simple traffic ticket amendment to a misdemeanor plea agreement and even some scheduling for a pending jury trial. Nagarjuna Dukampudi, whose traffic ticket had a bit of confusion. Defense counsel asked whether the township's ticket overlapped with possible state charges. Judge Washington cut through the uncertainty, clarifying that under the ticket before her, there was only one charge, failure to yield. After confirming with the attorneys, she allowed an amendment to impeding traffic, dismissed the original count, and accepted counsel's admission on behalf of the client. The fine was set at $180, with payment due by September 8. Dukampudi wasn't present but was represented, and the tone was pragmatic and efficient, the judge making sure no one left unclear about what had actually been charged. Next came Aaron Teachout, and here the stakes were higher. Represented by John Vincent, He accepted a plea to an added count of domestic violence, first offense, with an agreement of no upfront jail, referral to probation, and an alcohol assessment. Judge Washington carefully walked him through his trial rights, reminding him that once waived, they were gone, and that this decision would almost certainly stick without appeal. Teachout, calm but subdued, admitted he struck his live-in partner during an argument, providing the factual basis for the plea. His demeanor was respectful, answering yes or no without hesitation, and the judge emphasized he must schedule a presentence interview immediately. Sentencing was set for September 22nd. Finally, Devon True appeared for a pretrial. Her attorney asked if the final settlement conference could be pushed earlier, but Judge Washington firmly said no, sticking to the schedule. The matter was set for October 31st via Zoom, with jury selection scheduled in person for November 7th. True was cooperative and polite, thanking the court as bond was continued. The overall atmosphere was steady and procedural. Judge Washington was patient in clarifying the scope of charges, thorough in making sure Teachout's plea was knowing and voluntary, and firm in keeping the trial calendar intact. Defendants varied, some absent but represented, others present and cooperative, but all were handled with fairness and clarity. If you found this hearing insightful, consider subscribing,